that everyone?
I believe so.
Okay. Let's go ahead and proceed on the motion to reconsider. Go ahead.
Mr. Gonzalez is not turned on.
You're muted.
Is anyone going to make an argument on this one?
Can you hear me now, Your Honor?
Yeah.
I apologize. I was trying to unmute myself. Your Honor, Esteban Gonzalez on behalf of the movement regarding the motion to reconsider. This court back in October 25th ruled in a motion for summary judgment proceeding that the plaintiff, our client, Taruk and Capital Investments, was based on the representation of the defendant or the plaintiffs that they served as a residential mortgage loan company and therefore should have been or would have been or could have or should have been a residential mortgage loan under the statute of the Texas Finance Code to proceed toward what they achieved as foreclosure, a gaining of the property under that process. We would point out, Your Honor, that with particularity and to reconsider, under the Finance Code, while it does stipulate what has to be a residential mortgage loan company in the state of Texas, it does stipulate that it is one that engages in the business of residential mortgage loan origination on residential real estate in the state. And that occurs when, as you know, a residential mortgage loan application or offers or negotiates the terms of a residential mortgage loan. Again, defining residential mortgage loan, this is a loan primarily for personal, family, or household use. The documentation that was provided to the court in our motion is based on an agreement and a note and deed of trust that was taken out by the plaintiff. And with regard to the purpose of that note and deed of trust, it was stipulated under our Exhibit 1-4, in addition to the note and the deed of trust, which is contains commercial language. In addition, that the affidavit purpose stipulated that the loan was being obtained for business purposes for the purchase and sale and or rehabilitation of the property in dispute today. Our position, Your Honor, is that despite the fact that plaintiffs would say that we had to be, that our client had to be a commercial or a residential mortgage company, is far from accurate. This was never intended to be a residential mortgage. This was never intended to be anything for the dwelling of a family purpose. This was a commercial loan given to the plaintiffs and stipulated that it was to be under very, very articulated terms in the agreement for commercial purposes to rehabilitate and or sell the property at some later date. Despite the fact that plaintiffs have continued to tell the court or ask the court to believe that we needed to be a residential mortgage company, they've offered nothing in return that even stipulates that what they took out as a loan in of itself was a residential mortgage. It was not. The fact that they owned it, the fact that they were putting renters in the property and receiving profit reinforces the fact that it was to have been given, the funds initially were to be given under the auspice of a commercial loan for business profit. Now, I find it striking that not only were they securing rental properties and getting rental payments, the fact of the matter is, and what we're here for today, what this has all been eventually discussed or previously discussed, is that they were making profit off the property, but again, failing to pay their debt obligation back under the terms of the commercial loan. So what we would ask the court is not to characterize this property, this house, as the primary driving force of the loan. It was never designed to be a residential mortgage. It was never designed to provide the business LLC with a resident type of situation. And again, if they're taking profits in exchange, then it should at some point, like any other type of potential construction loan, been converted into some type of residential mortgage if that was the option or the goal of the LLC long range with owning the property. And again, Your Honor, this is not, and I understand the court's sensitivity to foreclosure issues. I've been in front of you many times with that aspect, but this is not the traditional type of lender foreclosing on a residential property to displace people. This was an assigned note of commercial value given to our client that was non-paid, that was noticed properly, and at the same time, Your Honor, was now deemed to be converted into some type of residential mortgage position. It was never designed to do that. And we would ask the court to reconsider that position, reconsider the judgment that was given, because again, it's unjust. It's asking our client who took this note under assignment, they did not originate, they did not provide the initial capital, but at the same time, this was a purpose that was to have been for commercial profit and value. This was not to have been, as the parties agreed, to be used for residential, particularly to the LLC, but nor can they have their cake and eat it too. At the same time today, saying to you, Your Honor, that, oh, well, it was a residence and therefore Turoc's capital procedures to enforce should never have occurred because one, they weren't recognized as a mortgage lender. We never stipulated that we were a mortgage lender because this in its essence was not a residential mortgage loan. This was a business loan taken out by the LLC. And it would be unjust, Your Honor, we believe that at this point to try to convert what is clearly in documentation, a commercial venture into some type of hybrid residential loan that would, again, benefit the LLC long-term and deny our client of their potential to enforce what was given to them under the terms of the original note and deed of trust. And that was a commercial valued loan.
Response?
Thank you, Your Honor. So the Texas Finance Code states that they may not participate or engage in the activity or business of a residential mortgage loan company without proper licensure. And due to the nature of the property and the loan itself, both being residential as defined by the Texas Finance Code, which states that residential property is real estate that is properly developed and zoned living, such as a single family house, apartment, or mobile home. It does not matter that they were collecting rents for it to be commercial. It's still defined as residential property. And as such, they needed proper licensure. And that was the entire basis of our 91A motion.
Yeah, I think I've already ruled on this issue. I thought you were also challenging the amount of the attorney's fees. Am I wrong about that? Mr. Gonzalez?
Mr. Hokar, you could answer on that one. I don't believe we were, Your Honor, other than to get clarification in our another motion, the clarification of the order.
Your Honor, if I may interject real quick. We were challenging, there was $3,500 in attorney's fees awarded, but there was no evidence presented on those attorney's fees. It was never requested during the prior hearing. And the court, during the hearing, made no reference to those fees being awarded. So they were just never even discussed at that time. So we were asking, sorry, go ahead.
I know the law changed on 91A, and I don't recall exactly. Is this a period of time was when this motion was filed, or are we under the new law or the old law? Or is it required that I award attorney's fees under 91A, or is that optional at the time for this particular motion?
It would be optional, Your Honor.
Is that right, Ms. Rodriguez?
Yes, Your Honor.
All right, then I'm going to vacate my award of attorney's fees in this case, but otherwise I'm going to not change the order. So, Ms. Rodriguez, if you could submit a new order that vacates the attorney's fees award. Anything else today, guys?
Yes, Your Honor. We also had we had filed a motion for clarification of the order. The order says that it was granting both a 91A motion to dismiss and motion for summary judgment on Turac's quiet title claim. And so we're just seeking clarification on if that was accurate, or if it was meant to be only the 91A motion to dismiss or the motion for summary judgment, just so we know.
Let's just make this as clear as possible. I'm going to go ahead and grant the motion. So, Ms. Rodriguez, I want you to also include in the new order that I'm granting the motion for summary judgment, and I'm denying the motion to dismiss under 91A, because I really don't think that's appropriate in this particular case. And I'm also denying the request for attorney's fees and sanctions, but the summary judgment is still in place.
Yes, Your Honor.
Anything else, guys?
I believe that's it. Thank you very much for the clarification, Your Honor.
Okay, just get a new order at the beginning of the order, like you did before. Just say on November 11th, that I granted in part, denied it, or actually, Mr. Gonzalez, you can prepare this. I granted in part, denied in part the motion for reconsideration, that the summary judgment stays in place, but the rest of the relief is going to be vacated, and the attorney's fees award and cost award are vacated as well. So, and then share that with Ms. Rodriguez and Ms. Cadillac, and get that to me as soon as you can.
Will do, Your Honor.
But all right, thank you so much, guys. Anything else?
No, Your Honor.
No, Your Honor.
You guys have a great